The judiciary has been blamed recently, especially by the executive, starting with Ruto, said it is frustrating its efforts. And of course, afterwards, the lieutenants of the executive as well as the legislature have been quite on a rampage, taking on the judiciary head-on. Tonight we discuss judicial independence and the rule of law with none other than the President of the Law Society of Kenya. Thank you so much, Council, for joining us. Welcome to our studios. Brilliant. And of course, it's your first time here, right? Karibu sana. Well, I want to pick your mind regarding what came to your mind when the President uttered those words last week and, sort of seemed to be taking on a war with the judiciary.
I was quite shocked by those words. Of course, we have been seeing a situation where gradually the comments that have been coming from the executive have taken on the note that the judiciary is frustrating government business. And at a certain point, we felt that is the normal reaction to when a decision does not go in your favor. But again, there have been one or two pronouncements before that that seem to suggest that when it comes to certain things, that the executive was keen on, then they were not going to take any opposition. Of course, you remember there was mambo ni matatu phrases and those kind of things. So there's been a gradual build-up on a narrative that on the things that the executive wants. It should not be questioned. And no one should challenge them. But the manner in which the president then came out, guns blaring, and making the kind of pronouncement that he was making. And then, even though we had seen that move towards trying to suggest that the executive enjoys a much more privileged position among the three arms of government, that for us was out of character.
What then happens? Because we see the President has his legal advice. Do you think that administration in, president in, president out, they seem to have their own moment of attacking the judiciary?
Yeah, precisely. And we attribute this to the hangovers of the yesteryears. We attribute this to the fact that power corrupts, and absolute power corrupts. Absolutely. And so in the kind of constitution that we have, a constitution that is best defined by a system of checks and balances, and that those checks and balances work best when they restrain the unbridled exercise of power. And so at a certain point, when you want to exercise power, you want to exercise it to the fullest extent, but there are limits of how that power can be exercised. And I think being reminded that power has certain limits is something that the political class seems to have a problem with, because I think the national mood, our political psyche is that everything is possible because after all, you occupy a certain office, and so everything is possible. And I think when that restraint of power then is exercised by other arms of government, remind the other arms that this is not possible, then you have this tension. So it is a tension that we are likely to see going into the future until we get to the level where we mature as a democracy and as a country and have truly dependent institutions that have come of age, and then that respect is likely to be restored.
The Constitution of Kenya 2010 that we passed as a country provided provisions, especially even is aggrieved about any judicial officer, they go through the Judicial Service Commission. Previously, we did see even when President Uhuru Kenyatta, the former president, had refused to swear in the 6 judges. Chief Justice Maraga told him that use your intelligence and then go ahead and follow the procedures. Why then does it seem to be a problem to follow from the executive what is prescribed in the Constitution? Because if I have a problem with you as a judge, I will then go to GSC and report and file a complaint. Where is the disconnect in all this?
And that is a very important question because what it ultimately speaks to is the concern that all of us have. There are very clear procedures that are laid out for anyone who has any allegation against a judicial officer or a judge to present it to the relevant constitutional organs that will look at it. And there is no gap in the scheme of things. There's no gap. The reason behind the establishment of the Judicial Service Commission, the reason behind making provisions that where there are complaints, they will be presented to the Judicial Service Commission. The reason why the President has representation in the Judicial Service Commission in the form of the Attorney General, why we have someone from public service, why we have someone from law society, why we have someone from judiciary, and why we have representation from persons representing ordinary members of the public. Is so that we can protect the independence of the judiciary. So it is a very deliberate scheme that is designed to ensure that you have people from diverse interests that would be able to look at a complaint and come to a very fair and rational decision. And so therefore we cannot defeat the intention of the Constitution to create a framework that guarantees the independence of the judiciary by seeking to hijack those processes and by politicizing the process. And you see what is unfortunate at this particular is that there is a wholesale condemnation of the institution of the judiciary. Would we be fair, for example, to say that the entire cabinet is corrupt? It wouldn't be fair. We have to say so and so is corrupt, and this is the reason why, and this is the basis why we make this allegation. But also, what is extremely critical is that in the process of removal of a judge, the president has a role that he must play. And so the natural thing to do is to wait for your turn in the queue. And the complaint will be processed and eventually it will come to you. And you will act as the Constitution provides in terms of what your role is.
So when we come to hear of such accusations, such allegations, Perhaps, according to the natural law or even allegations as they were, if more than three people seem to be alleging something about you, then people would begin to raise an eyebrow. So does the president have a point? Is he justified to say that, whatever he's saying about the judiciary as a whole?
It's really far from it. We have to examine the role that the president plays and our constitution. The president is the custodian of the constitution.
And he's sworn to protect it.
He actually was given a sword for purposes of protection of that constitution. That constitution embodies the sovereign will of the people of Kenya. And the president is then the custodian of the sovereign will of the people of Kenya. So what have the people of Kenya said? The people of Kenya have said that when it comes to the judiciary and to the exercise of judicial power, those judges should not be subject to any other control or command other than the Constitution. That is what the sovereign people of Kenya have said. And that is what the president has sworn to protect. And so when we question an action or utterances that have been made by the president that go against the Constitution, we are actually telling him that he is violating the people's supremacy, because it is the people who have decreed the manner in which judicial function and judicial authority is supposed to be exercised. So the question of whether the president can actually make this allegation of corruption within the judiciary is something that we can actually say given his status, given the fact that he has so many other organs and institutions that can actually look into this issue, investigate those issues, and when he finds, and then they are presented to the Judicial Service Commission, and the president acts. So the president cannot lead the charge by saying that so and so is corrupt. Because that goes against the overall scheme of things. And let me tell you why this is important. The institution of the judiciary stands between lawlessness and a lawful country. And it stands in between because people have confidence that when they have disputes, they will go to the judiciary, which is an independent arm of government, and it will resolve those disputes. So for our good and for the good of everyone, we take our disputes to the judiciary. So instead of fighting, we take our disputes to the judiciary, which we believe is an independent body, and it resolves those questions.
Okay.
The other thing is that as a country, as we try to bring in businesses, as we try to bring in investors, the first thing they want to ask themselves is, in the event, as inevitably happens in business, there is a dispute. Where do we go for resolution? So then we say that we will go to the courts. And that's why it is extremely important that the courts in any country enjoy legitimacy, enjoy public support, and that their authority is one that is not questionable and is not being undermined. So it is good for the country when you have a judiciary that people believe One is free of corruption, is totally independent, is transparent, and is accountable in terms of how it exercises its power. Because the moment that is not there, then what it basically means is that anyone who wants to come in puts that as a risk. And if they are proper businessmen, then they probably say, you know what, we can go to that country. But also, it speaks to how me and you will resolve our disputes. Now, if the president of the country is saying, even me, I can't get justice because this judiciary is so corrupt, incurably corrupt. Even me as the president of the country, I cannot get justice in those courts. What kind of message is he sending to ordinary mortals like you and me, who then are relying on the courts to resolve the disputes that we are having?
Because the question then comes in, where do Kenyans go to if the president will complain and say that the judiciary is corrupt, it is hindering and hampering his development agenda. Two, when you look at the situation, and even the people around him, if we call it per se, seem to be agreeing with what the president is saying, and even some quarters arguing that even if the president disobeys court orders, there is nowhere that he can go.
Well, I have seen those arguments. Yeah. But what does that mean? It means that the president has conducted a constitutional coup. Where he has elevated himself above the constitution. And that is not a healthy state of affairs for any democratic government. Any democratic government operates on the basis of checks and balances, on the restrained exercise of authority. Where any person then seeks to exercise unrestrained exercise on power, or unrestrained exercise of their authority as been donated to them by the Constitution, then you create a situation of anarchy. You create a situation of what we ordinarily call impunity. And that impunity is extremely dangerous to a growing economy and a country that is trying to come out of a difficult period that we have witnessed. One of the things that we must never forget is the history of this country. And that is why when it comes to interpreting even the Constitution, one of the things that we look into is the history of the country. What led people to make certain provisions as they are contained in the Constitution? What lessons? And when we look back, we see the lessons that we learned from a strong arm executive, the dictatorial issues that we went through with a strong executive. And that is the reason why Kenyan people said, you know what, even though in an ideal situation, we have three arms of government that check one another. We are even going to add an additional arm in the form of constitutional commission that will be checking how power is exercised. So that history then is extremely important as a country. And as we ask ourselves just how important some of these things are. And the one thing that I keep saying that the problem with things like rights, human rights, as contained in the Constitution, they sound like catchphrases until the day it happens to you. Until the day you go to court and the court cannot enforce your rights, or you are given an order of court, and somebody looks at it and says, this is just a mere piece of paper, because the authority that is supposed to be contained in the order that the court has been taken away. At that point, it sinks. And for us, we do not want to get to that level where people begin to ask themselves, does it make sense to go to court anymore to resolve our disputes?
You've even had there's sentiments coming in. Why hire a lawyer when you can bribe a judge?
Yes, those are now the graphic illustrations of the operation of inefficiency and corruption within the judiciary. So the one thing that must be emphasized in this discussion is that no one should countenance or tolerate corruption within the judiciary.
So there is this statement that Hussein Mohammed, the spokesperson produced on the third, and I'm sure you've had an opportunity to go through it. He started by saying the Law Society of Kenya has purported to advise President William Ruto on constitutionalism and specifically the independence of the judiciary. They did not. What was going through your mind, especially when you saw this?
I almost thought that it is a tragic attempt at comedy. It was a tragic attempt at trying to simplify the very grave concerns that we had raised. But one of the things that should not be lost is that that statement was issued on the same day that we gave our statement about 9 p.m. So the speed at the rebuttal told us that the message that we had put out had hit home. And so there was an attempt to struggle to respond to it and to try and water down the very grave concerns that we had raised. And so what we have since witnessed thereafter have been these attempts to try and justify all these comments. And I think that is what this statement was intended to do, to try and speak from both sides of the mouth, because the statement cannot on one hand say that we support the judiciary, that we are going to protect the independence of the judiciary. And then on the other hand, purport to say, you know what, we are also not going to agree when the judiciary is the one that is torpedoing government projects. And I think that's at that point where you begin to see where the tragic comedy is. That on one hand you're trying to say this is what we are doing, but on the other hand you're also trying to say that this is not. So the point that I was making is that as a country, generally, I think every institution is struggling with the question of corruption.
Yes.
Now, within the judiciary, the question of corruption is actually much more sensitive and much more tragic, because the judges are actually priests in the temple of justice. And so they are required to be above reproach. They are required to be of the highest levels of integrity. And so therefore, any whiff of corruption within the judiciary, any whiff of incompetence among the judiciary should be frowned upon, should be dealt with decisively, and should be cut off from the judiciary as fast as it possibly can, to avoid spreading and infecting the rest of the temple of justice. So that is how critical it is. And so as a society, we have continuously advocated for the highest standards of integrity within the judiciary. We have called out corruption when we have seen it even if it is the manifestation of corruption, because sometimes you look at a decision and you can say that even though I have no evidence, the only plausible explanation as to how this decision could have been arrived at is through corruption.
Okay.
And we have seen so many of those instances, and we keep on highlighting those instances. So I think all of us have a moral duty and a moral obligation to fight corruption within the judiciary, to highlight instances of corruption within the judiciary in a manner that enables us to root out those that are corrupt within the judiciary. And that is the basic minimum. But the reality is that they are actually good judges. They are good judicial officers within our judiciary. And there are a few rotten eggs also. So we need to get rid of the rotten eggs so that we can remain with people of integrity. But what we are witnessing is a wholesale condemnation that is only intended to achieve the collateral objectives. And of course you cannot lose sight of the fact that the allegations of corruption against the judiciary are followed by a statement that says we will not allow the judiciary to frustrate critical government projects. So if the orders are not given against this critical government project, then the judiciary will be clean. And I think that is where now it becomes extremely subjective, and the objectivity in the very good rationale of ensuring that we reduce or eliminate corruption within the judiciary is lost.
That's you've spoken about that we will not allow the judiciary to frustrate government efforts. Does then this prescribe a situation where we shall perhaps maybe not start seeing judgments and rulings and orders that seem to be going in tandem with the executive? Does such a scenario seem to be foreseen in following such remarks and sentiments?
We are going to be watching out for that. And it will be extremely unfortunate if the judiciary succumbs to this latest arena of threats and intimidation. Because then they would have betrayed the Kenyan people. They would have failed to live up to the oath that all of them have taken. And it's part of the reason why as the Council of the Law Society did call out its members for a peaceful protest march that will be preceded by the lawyers retaking their oaths in public, so that we can affirm that as a body of lawyers we stand ready, able and willing to defend the rule of law, to defend the administration of justice, the independence of the judiciary, and our constitution. And so there we also expect, because to a larger extent, the members of the judiciary are also members of the law society, because they are first advocates before then they join the judiciary. We also expect, because they have taken a similar oath, that they will also abide by their oath. And in this process, they will not only uphold the oath that they have taken, but they will also ensure that they act with integrity, because it is that they are called to do. And we will be asking them as we undertake this process, that they also recommit themselves to the words of the oath that they took.
Because moving forward, even as into the home stretch of this conversation, I'm seeing some feedback here. Njeru from Chuka Tarakanidi is saying you're enjoying the show. Thank you so much for staying with us. Of course, keep your questions coming. There is one asking here, what happens then to judges and their independence, even as they issue their judgments? I think you just addressed that. I was going to the point of looking at the whole spectrum of the rule of law. Do you think as a country we seem to be taking an upward trajectory? Are we stagnating, or are we going downwards in the adherence to the rule of law?
The assessment of that largely is determined by how the state behaves and responds to court orders. And I think
has this government been adhering to court orders?
I think that publicly they started off on a very good note by saying, we are going to comply with court orders. We remember that there are several decisions that have been given by the courts, which all the executive was happy about, and other institutions, even Parliament, they have actually largely complied with those decisions. So to that extent, we were happy the first few months of the term of this administration. But as time has gone by, we have seen talks and discussions that tend to suggest that the law is now becoming an inconvenience on the part of the state, and they're getting extremely frustrated, and they want to say that we will not be bound by this decision. We disagree with them and we will not be bound by them. And so that public rhetoric is one that is extremely dangerous to the rule of law in this country. And we would want to urge the executive and the entire Kenyan population that and we have seen this happen. We have seen strong men of the law. We have seen those who abused the law in the last administration. When this administration came in, they were running all over the place. And that is what automatically happens. If we do not support strong institutions, if we do not support the rule of law, if we cut corners with the rule of law, it will come back to bite us at a particular point. And so I think for us, it would really we would build this country more if we are able to say that though we may be extremely aggrieved by certain decisions that the courts will make, but we have to live with those decisions.
On that important point that you mentioned of the law will come to hand, those who are there right now, do you think that those that are in the administration, the executive right now, realizes that? Do you think?
I don't know because you sometimes get the feeling that sometimes when people are in power, they lose sight of just how critical some of these things are. And you actually realize that they are losing sight in terms of the nature of the justification that they give. That if you go back a month or two or a year back, when other extrajudicial measures were being used against them, they were the first. They were at the front line of urging the judiciary to be independent. They were at the front line for urging for the respect of the rule of law. And so you find this like a case of musical chairs that when it was convenient, they supported the independence of the judiciary. They supported the rule of law. They supported the administration of justice. But now now that they find themselves on the other side of the decisions, then it is no longer convenient, and people are forgetting the statements that they were making when the law was being used, or rather being misused against them. And that illustrates that's irony. And so I think we need to say that at a certain point, this circus has to stop. And we have to get to that level where everyone knows that the law is consistent. Everyone knows that the law will be applied to all of us equally, irrespective of status in society.
So, looking at your statement, your sentiments that you're issuing, especially regarding this whole issue of the attacks on the judiciary, do you feel somewhat as a society frustrated? And one would wonder then, where does the judiciary turn to in the wake of these new attacks on that institution? And what then does the public do, whereas we've spoken a little bit about that, but what does then the public, in terms of mentally shifting and still having faith in this institution that seems to be attacked, especially by the other arms of government?
Yes, there is an element of frustration. But luckily for us, the law society has an illustrious history in the quest for constitutionalism, in the quest of supporting the rule of law and upholding the independence of the judiciary. So we can say that when it comes to experience with regards to dealing with those questions, that there is no institution that is as well versed in dealing with those challenges more than the law society. And it is now a question of going back to that history. It is a question of relying on that experience and the experience who came before us, who stood so valiantly in support of the rule of law and in support of the constitution and human rights and the democratization of this country. And to learn from the experience, to draw inspiration from the struggle that they did, and to mount the kind of struggle that we are doing. And to that extent, then we know that the true test of loyalty, of liberty lies in eternal vigilance. It is not a battle. It is actually a war. It is a process. You have to keep challenging. You have to keep challenging. Even when it is not making sense. And sometimes you may wonder, because if you look at the last administration, when especially they refused to swear in judges, there were cases after cases that were filed by the law society. And the issue here is one of the principles. If the principle is correct, then we support it. And we say this is the correct interpretation of the law. Whether you're going to obey it or not, we will keep challenging, because the moment we keep quiet, then we become part of violators, because now we are supporting it through omission by failure to respond. And so I think for the law society, we have no alternative. We have no alternative for as long as the constitution is under threat, for as long as the rule of law is under threat, for as long as the independence of the judiciary is under threat. We have no other obligation to speak about it, and to take action, and to speak until when the storms hear us.
Will the stones hear you?
Well, I think that if you look at the history of the country, this has happened time and again. But overall, the Constitution and the law has prevailed.
Absolutely. Indeed, LSK President, that is Eric here in studio speaking to us on judicial independence and the rule of law. I see some feedback. Kabando on X saying the Law Society of Kenya is performing its statutory duty by pinpointing the executives over which LSK Council and Eric is steadfastly protecting public interest, and that is how it should be. It is a noble patriotic assignment. And also Visha watching in from Rumba, watching from Nyahururu saying you're present, as well as Njeru Muria from Chukatharakanivi. Simon Agakonye, thank you so much for your tremendous feedback. That's why we end up the show right here on the Daily Report on TV 47. My name is George Maringa. I'll see you tomorrow. As always, stay safe and be kind to one another.